Judgment in the appeal IA and Secretary of State for the Home Department.
Lord Kerr will summarise the judgment of the court.
The appellant in this case has been referred to throughout as IA, and that is because he's considered to be at risk if his identity is revealed. IA is from Iran. He left that country in 1998 when he was 16 years old, and he then went to Iraq. There he was recognized as a refugee by the United Nations High Commission on Refugees, and that was because he had been a member of the Kurdish Democratic Party of Iran, and he was afraid of being persecuted in Iran on that account. He left Iraq for Turkey in May 2002, and there again he was recognized by the UNHCR as a refugee. But nothing was done to send him to a country where he would be safe, so 3 years later he left Turkey and came to the United Kingdom. He applied for asylum in this country, but that was refused. And that was because his account of the circumstances in which he left Iran and then Turkey were considered not to be believable. IA appealed the refusal of asylum. The immigration judge dismissed his appeal, and his appeal against her decision was in turn dismissed by the Court of Session. One of the principal points that IA had made was that the fact that UNHCR had granted him asylum should rank as a significant factor in deciding whether he should be granted asylum in this country. The immigration judge accepted that, but she decided that there was enough in the material that had been presented about his credibility that made it possible to refuse his application. IA appealed to this court. Before his appeal was heard before us, the UNHCR disclosed a number of documents relating to the grant of refugee status to him. And those documents, we found, supported the consistency of IA's case on a number of points. But notwithstanding the production of this new material, we have decided that the appeal must be dismissed. We considered that on the material that had been presented to her, there was enough reason for the immigration judge to doubt the truthfulness of the appellant's account. She was entitled on that material to disbelieve the story that the appellant had given. But although we dismissed the appeal, we considered that there was substantial support for the appellant's claim in the material that the UNHCR had produced. On this point, we have given guidance about how a decision whether to grant asylum should be influenced by the fact that UNHCR, with its unrivaled experience and expertise, has decided that refugee status should be granted. One option available to us was that we could remit the case to the immigration judge because we felt it was probable that she might have reached a different view on IA's credibility had the UNHCR information been available earlier. But we decided that the better course was for IA to submit a fresh claim under Rule 353 of the immigration rules. It seemed to us likely that the Secretary of State would be satisfied that the new material created a reasonable prospect of success and that his application for asylum would be accepted as a fresh claim. IA can therefore start again and seek to persuade the Secretary of State that his claim to asylum should be granted, not least because of the information that has been received from UNHCR.
The court is now adjourned.